Good afternoon, ladies and gentlemen. Thank you very much for watching our presentation today. Me, Sukhdev Kaur from Law Chambers of Sukhdev, together with Jeannie Seelan from JS Partners, we will be speaking about the incorporation of a company and directors' duties. Jeannie, would you like to introduce yourself?
Welcome everyone, I'm Shivajini Seelan from JS Partners, and we are a one-stop firm that focuses on corporate affairs for SMEs. I will be talking about company incorporation, and Sukhdev will be talking about directors' duties. What is the requirement to incorporate a Sindra and Berhad? Companies Act 2016, which was in force in January 2017, basically requires only one director to be the sole director for Sindra and Berhad. Section 2 defines the director, which Sukhdev will then elaborate later in her slides. And compared to Companies Act 1965, which you required 2 directors, now we only need 1. So it makes it very much easier. Who can be a director? Section 1962 and 1964 basically focuses on a person who is a natural person of 18 years of age and who ordinarily resides in Malaysia. And that's basically the 2 important criteria for forming a company.
Jeannie, may I ask you a question here?
Sure, Sukhdev.
What about foreigners? Are foreigners allowed to open a company, incorporate a company in Malaysia?
Okay, that's a very good question. We get a lot of these questions. In fact, it's a very catch-22 situation because a foreign person without a work permit or an employment pass would not be able to incorporate a company. He would need to have an employment pass or a work permit before he can actually incorporate. Therefore, for a company to first start up, he would need to use somebody else first who will be able to be a director and then come in a later stage where he gets his employment pass.
Thank you.
You're welcome. Now, the benefits of being a single director. Having a single director, of course, it avoids any director's disputes. You'll be able to make decisions on your own. And it, of course, eases the incorporation process. And, of course, any resolutions and documents that need to be passed will only be signed by yourself. So it's a very easy situation when there's only one director. But if in any situation you need more than one director, we will obviously recommend at least 3 to 5 directors, which would be easier in terms of a vote equality and of course to pass any resolution. Companies can anytime switch from one director to multiple directors at any point of time. So even if you decide as 1 first and eventually 3 or 5, or from 3 to 5 to eventually 1, it can also happen and it's not an issue. Steps for incorporating a company. First step, name search of the name proposed. Of course, this is the most important. There are certain names that are gazetted, and if there is an abbreviation to the names, we would need what it stands for. If it's a name of a director as well, we would need details. If it's any other name, we would need what does his name actually mean, and it's what basically it means. The name process basically takes 1 day if there's no issues. And basically the next step is the step 2, which is the incorporation of the company if the name is approved. Incorporation of the company will need the full details of directors and shareholders, and this is when we need the full residential address and the shareholding structure of the how the shares is going to be and the paid up capital. Step 3, of course, is opening bank account, which we will need details of the bank name, bank mandate, and the bank address. Yeah, and you've got your company started. Yeah, and we've got very good news this year, of course, with the tax rebate. If you incorporated your company on the 1st of July 2020 till 31st December 2021, the government has introduced a tax rebate of for the OPEX and CAPEX, which is basically the operating expenses and capital expenses. If you spend a minimum of, basically if you spend 20,000, you will get a 20,000 tax rebate. If you spend 10,000, you get a 10,000 tax rebate. Of course, the company needs to be in operation, and it obviously is applicable to SMEs and Sindra and Berhads and LLPs. Yep, so that's something you can take advantage of. And thank you. I'll pass you on to Sukhdev, who will speak about directors' duties.
Thank you, Jeannie. That was very
You're welcome.
informative. So,
Thank
ladies and
you.
gentlemen, I shall speak about the exercise of powers by directors. The directors' duties and responsibilities are codified under the Companies Act 2016. Section 2 of the Companies Act defines and interprets a director as any person occupying the position of a director of a corporation by whatever name is called. And this includes a person in accordance with whose directions or instructions the majority of directors of a corporation are accustomed to act, and as an alternative or substitute director. So under Section 210 of the Companies Act, the directors includes Chief Executive Officer, Chief Financial Officer, Chief Operating Officer, or any other person primarily responsible for the management of the company. Having said that, the primary duty of the director is that the director owes a duty to act in the best interest of the company, because the company is a legal entity of its own. So best interest of the company is subjective. It is dependent on the facts, circumstances, and issues surrounding the company. This duty to act in the best interest of the company is embedded in Section 213, Sub 1 of the Act, where the director of a company shall at all times exercise his powers in accordance with this Act for a proper purpose and in good faith in the best interest of the company. The standard of care, skill, and diligence that is expected of a director in carrying out his duties is stated in Section 213, Sub 2 of the Act, where he has to carry out with knowledge, skill, and experience that is reasonably expected of a director having the same responsibilities. What this essentially means is that the decision that is made by a director for the best interest of his company, whether a director holding the similar position in another company would also make a similar decision. If that is so, then you can say that this director has exercised his reasonable standard of care, skill, and diligence in coming to that decision. Generally, a director does not owe a duty to the company's shareholders unless the interest of the company's members as a whole is at stake. Then in that situation, the director must act for the best interest of its shareholders. Section 214 of the said Act provides for the business judgment rule. I'll repeat. Section 214 of the said Act provides for the business judgment rule, which essentially means that any decision on whether or not to take action in respect of a matter relevant to the business of the company whilst meeting the requirements of the duty. Hence, by virtue of Section 214, the directors is deemed to have made a business judgment, and this will be reflected on two principles at common law. Firstly, the courts will prima facie presume that the directors have exercised their powers in good faith and in the best interest of the company. And secondly, the court should refrain from substituting its judgment for the judgment of the directors, since the management decisions are made in the boardroom and not in the courtroom. The person who is alleging that the director has failed to make a business judgment will have to provide unrebuttable evidence that the conduct of the directors are actuated by improper motives and mala fide. Now, at present, the decision of the court that speaks about the director's duties, the standard and the burden, business judgment rules, is in the case of Pioneer Heavens Sdn Bhd against Huhab Construction Company Berhad. Now, of course, because this is a very subjective matter and it is dependent on the facts, issues, and that is surrounding the individual company and the director, these decisions of the court will have to be read with other further decisions that are made by the courts in order to decide whether or not the director has actually acted in good faith and in the best interest of the company.
Okay. So I wanted to ask you, Sukhdev, what are the elements that would decide if a director has complied with its duty to act in the best interest of the company?
Thank you, Jeannie. That's in my next slide,
Okay.
where I'll put it in summary. The directors is said to have complied with its duty to act in the best interest of the company when the director fulfills the elements set out in section 214 of the said act, which are makes the best judgment for a proper purpose and in good faith, does not have material personal interests in the subject matter of the business judgment, is informed about the subject matter of the business judgment to the extent that the director reasonably believes to be appropriate under the circumstances, and reasonably believes that the best judgment is in the best interest of the company. Does that answer your question?
Yes, it does, Sukhdev. Thank you for the informative details.
Thank you.
For director's duties.
Welcome. Okay, with that, ladies and gentlemen, we end our session for today. Please feel free to contact us should you require any further queries and clarification. Law Chambers of Sukhdev is a civil litigation firm. And Jeannie?
And I'm from JS Partners, Shivajini Seelan, signing off.
Till next time. Thank you.
Yeah, we'll
Take
meet
care
next time.
and stay safe.
All right, bye.